Greetings. As I mentioned to you last time, I'll be uploading some videos and producing some podcasts dealing with the foster care and adoption system here in the state of Arizona, as well as covering some topics that are more nationwide in their expanse. Today is going to be the first video that I'm uploading, and if you like what you see, please let me know. Leave me that feedback. Similarly, if there's something that I'm not covering or a subject or topic that you'd like to hear more about, please let me know that as well, because it's you that's important. It's serving you and responding to the questions that you have. That forms the purpose of what I'm doing today. So for my first in this series, we're going to have a generalized discussion of adoptions in Arizona. This will cover the general topics of who can be adopted, who can adopt, where you can adopt, what the requirements are to adopt, both on the person seeking to adopt as well as on the person being adopted, how long it takes to adopt somebody, can adoption be challenged or set aside, and finally, what happens after the adoption. So the first topic is, who can be adopted? Are there any limits on that? Who can be adopted is covered by Arizona Revised Statute Section 8102, and that's a child, someone under 21 years old. It can be a foreign-born person so long as they're not an illegal alien and they are present within the state. Now, if a child is placed by the department in another state, that child can be adopted in the state of Arizona in accordance with the Interstate Compact on the Placement of Children, a subject that we'll cover later.
A question I'm often asked is, can adults be adopted?
Yes, in the state of Arizona, an adult can adopt another adult so long as the person who is sought to be adopted is between 18 and 21 years of age. They obviously have to consent, and in addition, if either of the parties is married, their spouses will have to consent as well. There is an exception to this. If the person who is sought to be adopted was actually as a juvenile in the foster care of the person who is seeking to adopt, and they lived in a family type of setting for a period of at least 5 years, that person can be adopted by the former foster parent. And there doesn't seem to be an age limit associated with this, at least insofar as Title 14, Section 8101 is concerned. Now that we've covered who can be adopted, the question turns to who can adopt. Section 8103 provides that any adult resident of the state of Arizona is eligible to qualify to adopt a person. Spouses do not need to adopt a child together. In other words, one spouse or the other can adopt. However, only a married couple can adopt jointly. At this point, there are two aspects that I'd like to discuss a little more in detail. I just told you that only a married couple can adopt a child jointly in the state of Arizona. A married couple is a couple that was legally married. That includes same-sex couples. So long as they are legally married, they can adopt a child in the state of Arizona. There is no prohibition against that, even with the Department of Child Safety. So yes, a same-sex couple, so long as they're legally married, can adopt in the state of Arizona. Secondly, if a child is placed in another state, say California for the purpose of an example, they can adopt in the state of Arizona under certain circumstances. First of all, that child has to be a ward of a county of the state. In other words, taken into services by the Department of Child Safety. That child then has to be placed with the prospective adoptive family in my example, California, by the department in accordance with an ICPC or Interstate Compact on the Placement of Children application. And that child has to reside with that prospective family for a period of at least 6 months before the adoption can take place. More importantly, that receiving state, again from my example, California, has to approve of the adoption. I'm going to cover the Interstate Compact a little bit later in this discussion. But yes, an out-of-state child who is a ward of the state can be adopted in Arizona. Oftentimes, we do adopt or finalize the adoption here in Arizona because it's quicker than can be done in that receiving state. Okay, so that brings us to a discussion of the Interstate Compact on the Placement of Children, or the ICPC, as you may have heard it called before. This is a subject that will be covered much more in depth in a later presentation, but suffice it to say that if a child's not in the care of a family member and is sought to be placed across state lines, the ICPC has to be complied with. The sending state, meaning the state where the child originated, has to coordinate with the receiving state, the state in which the child is sought to be placed, and certain assurances have to be made before that child can be placed. There's home studies in the receiving state, there's approvals and possibly certifications that have to be dealt with. The child cannot be sent and cannot be adopted unless and until that receiving state has approved of the ICPC placement. Furthermore, only children placed under an ICPC that have gone through the Department of Child Safety, in other words, are wards of the state of Arizona, can be adopted in Arizona. Again, this is a discussion that will take place in a later presentation, as it in and of itself is very in-depth. Now that we know who can be adopted and who can adopt, the question is, well, where do we adopt? Well, it's one of two places. It's either the county of the prospective parent's residence, or it's the county where the child to be adopted is a ward if that child is in services of the state of Arizona. A question that often arises is, what is residency for the purpose of the adoption statute? And firstly, you need to understand, under Arizona law, there is no clear definition of what establishes residency. Tax laws can be looked at to render some guidance, and generally, if you are domiciled permanently in Arizona, you have a full-time residence or a residence that you consider to be primary, and you possess an Arizona's driver's license, and you have a car that's taxed here in Arizona, you'll be considered to be a resident. Alternatively, they look at duration. How long do you stay here? And generally speaking, if you reside in Arizona for 9 months continuously, you are considered to be a resident. Now it's time to dig a little deeper into the adoption process itself and look at what are the requirements to adopt. The first requirement is certification of acceptability to adopt, and you need to examine as to whether or not you are required to be certified. Certification is basically the court's approval of the person as being acceptable to adopt somebody. And this requires the submission of a state and federal criminal records check and a social study or a home study, which includes the social history of the applicant, their financial condition and moral fitness, the religious background or upbringing of the applicant, as well as the physical and mental conditions of both the applicant as well as the person sought to be adopted. They'll undergo a central registry records check and report to indicate whether or not there's been any claims of abuse or neglect as against the applicant, and submission of a general statement of any other fact which bear on that person seeking certification's fitness. There are exceptions to the requirement of certification. Title 8, Section 105 of the Arizona Revised Statutes provides that if the prospective adoptive parent is the step-parent, adult sibling, aunt, uncle, grandparent, or great-grandparent of the child sought to be adopted, by whole or half-blood or by marriage or adoption, they don't need to be certified by the court as being acceptable to adopt. Similarly, if the prospective adoptive parent is the licensed foster parent of the child sought to be adopted, and that child was placed with them by the Arizona Department of Child Safety, they don't need to be certified as acceptable to adopt. If the prospective adoptive parent has previously adopted a child in the state of Arizona within the past 3 years, they don't need to be certified. They will have to submit to the court an updated or revised social study setting forth any changes in circumstances taking place since the last adoption. The last exception under 8105 is a little confusing, so follow along. If the prospective adoptive parent lives with and resides with the child sought to be adopted and that child's parent, aunt, uncle, adult sibling, grandparent, great-grandparent, or great-aunt or uncle, and that relative of the child passes away, as long as the prospective adoptive parent has resided with the child and that relative for a period of at least 24 months immediately prior to that relative's passing, they don't need to be certified as being acceptable to adopt by the court. Under all of these exceptions, however, the prospective adoptive parent will have to submit a criminal records check as well as a central registry records check before they can adopt the child, but they don't need to be certified. Consent of the parent or guardian of the person sought to be adopted is also required to be given. Consent must be received by the child's mother, the child's father, if father was married to mother at the time that the child was conceived or had previously adopted the child, or a paternity test established parentage. If the child's 12 years or older, they have to give consent to be adopted in open court. A court-appointed guardian has to give consent if that guardian has been given authority to do so. If the child's being adopted through an agency, that agency will have to give consent if the authority to place the child for adoption was given by its birth parents. Finally, the Department of Child Safety has to give consent if the child is a ward of the state. Now, department consent can be waived if it can be established with the court that it's clearly in the child's best interest that that waiver take place. And understand, once consent is given, it is absolutely irrevocable. So what if there's no father on the birth certificate? What then? What consent is necessary? Well, first, the mother needs to provide a notarized statement listing all possible fathers, any possible fathers. These are called putative fathers. And for each putative father, notice has to be given. That notice is set forth in Arizona Revised Statute Title 8, Section 106. Basically, they have to provide notice that the adoption of the child or children is planned, that the father can either consent to that adoption or withhold his consent to the adoption, and the father is required to initiate a paternity proceeding within 30 days of the receipt of the notice and has to proceed to a judgment of paternity. If he doesn't proceed to judgment, his consent is waived. The father does have the ability to seek custody of the child. And if that father does file for paternity and is awarded paternity, the father must begin paying financial support if that paternity is established. If they don't pay support, then that consent again can be deemed to have been waived. You may also have to submit a social study to the court, which differs from a certification home study. The social study required to be adopted is a little bit more onerous than the one that you went through for certification. It covers more child-specific information, such as the child's social history, heritage, and mental and physical condition, as well as that of its birth parents, the child's current placement and adjustments to the home, as well as the adoptive parent's suitability to adopt. They'll look at any existing and proposed arrangements regarding the child's custody and visitation, as well as financial arrangements concerning the adoption itself, whether or not any sums or funds were paid to any person in connection with the adoption. And then once again, that state and federal criminal records check and central registry check will have to be repeated. Just as there are exemptions from the requirements of being certified as acceptable to adopt, there are exemptions which exist from the requirements of submitting to a social study. If the prospective adoptive parent is the step-parent of the child and has been married to the legal parent of the child for a period of at least 12 months and has resided with the child sought to be adopted for a period of at least 6 months, no social study is required. In addition, if the prospective adoptive parent is the adult sibling of the child by whole or half-blood, or is the aunt, uncle, grandparent, or great-grandparent of the child, and the child's resided with them for a period of at least 6 months' time, no social study is required. Finally, if the prospective adoptive parent is the licensed foster parent or has previously adopted a child in the state within the past 3 years, they only need to submit to the court a central registry records check as well as a change of circumstances which have taken place since the last adoption or the last license renewal. No full social study is required. In all of these exemptions, they still have to submit to a criminal records check as well as a central registry records check, but they don't need to submit to a full social study. Now that you've completed your certification and you've got your social study and consents, what documents need to be filed with the court to initiate an adoption? The first document you file that initiates the adoption itself is the petition to adopt. This is usually a verified pleading, meaning it's signed by the petitioner, the person seeking to adopt the child, in the presence of a notary public. You're swearing that everything in that document is true. And there's a number of things that are outlined in the statutes that you have to allege. First of all, your name, age, and residence address. If you're adopting or seeking to adopt as a married couple, the date and place of your marriage, as well as your current relationship to the child. Are you a family member or are you a licensed foster placement? The date that you were certified as being acceptable to adopt by a court, if you were certified, as well as when the child was placed. When did you get custody of that child? As to the child itself, you have to indicate the date and the place of birth of the child and whether or not it's an Indian child and subject to the Indian Child Welfare Act. If you're seeking to change the child's name, you have to indicate what that new name is that you're seeking. You've got to also allege you have all the consents necessary, and you have to
Include a statement of the value of all property owned, possessed, or to be owned or possessed by the child in the near future. And you have to disclose anything you paid in connection with the adoption. Finally, and perhaps most importantly, is you have to include a statement that it is the desire of the prospective adoptive child and their parents to be adopted.
Rule 83 of the Arizona Rules of Procedure for the Juvenile Courts lists the documents that need to be filed with the court in advance of the final adoption hearing. First and foremost, a certified copy of the child's current birth certificate has to be filed. You can't submit a copy, nor can you submit a listing from the Bureau of Vital Statistics, information about the child. And this is important because this information will be used by the court, at least in part, in creating a new birth certificate for the child. It's being adopted, it will have legally new parents that will go on that birth certificate. And all of that information is necessary because with Social Security to change that information, you'll need that post-adoptive birth certificate. So that's the first requirement. Secondly, a notarized affidavit from the birth mother that we talked about before, listing all of the potential fathers, has to be filed, along with an affidavit of a paternity search. The fact that the putative father's registry, along with court filings, has been searched and that there are no unidentified fathers out there or prospective fathers. An affidavit of service of process on those potential fathers has to be filed with the court, along with an affidavit of compliance from an attorney or any agency involved, certifying that all of the requirements of the Arizona statutes have been met. A verified accounting has to be provided unless the adoptive parent is a step-parent. And this is where all costs associated with that adoption are going before the court to be approved. A notarized statement from the birth parents has to be provided, either granting or withholding permission for the child to obtain information about them and about the family when that child turns 18. In addition, if there's a communication agreement in place, a post-adoptive communication agreement between the child and the adoptive parents and any family members or the birth parents of the child, that original agreement has to be filed. The social study we just talked about has to be filed, as well as all original consents. Again, no copies of consents can be filed. They have to be originals. Once all of those documents have been filed by the court, I think you're ready to move on. Now that you have the petition filed, you've got everything before the court so the court can decide you're ready for the adoption hearing itself. Once the court's received all of your documents, they'll generally try to schedule the adoption hearing within 90 days. The law provides that they have to have a hearing within 60 days if the child's been in the home for a year, unless it's a step-parent adoption, or the 90 days if a child's under 3 when the petition was filed or has been in home for at least 6 months. In all other cases, within 6 months of the date of the filing of the petition, you'll have your hearing. Again, generally, courts will seek to set those hearings within 90 days of the filing. The prospective adoptive parents and the child or children sought to be adopted will have to attend the final adoption hearing in person, although a court may allow appearance through a deposition or through electronic means, telephone or an internet conferencing service. The prospective adoptive parents, as the petitioners, have the burden of proving by a preponderance of the evidence, meaning that it's more likely than not that they are fit and proper persons to adopt the child, and it's in the child's best interest and welfare to be adopted by them. Their testimony will be elicited to verify all of the allegations contained in the petition that they filed to adopt the children. In the event that one of the children or all of the children sought to be adopted are 12 years or older, they will have to testify as well. They'll have to give the court their consent to the adoption, as well as changing their names in the event that's what's sought. And that consent has to be obtained in a knowing and voluntary way, and it can't be coerced in any manner. In the event that there's any post-adoption contact agreements with the legal or biological parents of the children, those will be reviewed by the court at that time. In the event that one of the parents' rights had not been terminated, the court may terminate their rights at that time, or they may place the matter in abeyance, rule on the termination, and then rule on the adoption. Finally, the court will ensure compliance with the Indian Child Welfare Act to make certain that there are no issues that remain concerning an Indian child that's being adopted. So what happens after the adoption? What rights does the adoptive parent have as to the adopted person? Oftentimes I'm asked, is the adoption permanent or can it be challenged in any way? Generally speaking, yes, an adoption is permanent. Once the court enters an order granting the adoption, the adoptive parents are now legally the parents of the adopted person, as if they had given birth to that person. The court favors that permanency and disfavors setting aside adoptions, and in fact this Arizona law provides that if there are defects in the pleadings after a year, all defects are deemed automatically to be cured. There are ways in which an adoption can be open or set aside. For instance, if the adoption documents themselves were fraudulently submitted, they weren't really the mother's signature on the consent, for example, or that there's new evidence that establishes, hey, there is a father who didn't know about the child and he filed for paternity immediately, that is something a court would have to take a look at to determine whether or not he had notice and should have had notice. Please understand, if it's challenged, until that motion is ruled on, it has no effect on the finality of the judgment. And again, courts are remiss to set aside adoption. If you have questions, certainly seek the advice of an attorney. So I hope you found this to be informative. If you have any questions as a result of watching this presentation, please don't hesitate to reach me. My practice is the entire state of Arizona, and I have offices in Mojave and Yavapai counties, with my main office being in Prescott, Arizona. My contact information is on this slide, and again, I'd be happy to respond to any questions that you might have. Thank you again for watching this, and if you have any feedback, I would welcome it on this site. Thank you.